Federal judge is growing impatient with the bumbling and stumbling of the Trump administration and its Department of Justice, and more particularly, lies and mischaracterizations that she's being told by the Department of Justice. And it all spilled out into the open yesterday during a hearing in front of Judge Xinis involving Armando Abrego Garcia. I got great news. Armando Abrego Garcia was actually in the courtroom because he was released by order of this judge about a week ago. He was there. He's the poster child for all that's depraved and inhumane about Donald Trump's immigration and removal policy. He got to sit at the counsel table, in front of the judge, along with such a large group of lawyers representing him that the judge actually joked before she then tore a new one into the one Department of Justice representative who showed up, Mr. Molina, before she turned to Mr. Molina, where there was no jocularity. She turned to Mr. Abrego Garcia and his lawyers and said, "You look like you're represented by a baseball team. Ha, ha, ha. Not you, Mr. Molina. Sit down." The judge then just said, "Look, I got a problem with documents that are being filed in the case. The reason they were all together in the hearing was whether to extend the time to keep Abrego Garcia free through the holidays and beyond while the judge considers motion practice, and to make sure he doesn't get picked up in the middle of the night and thrown into the dark, dank cells of ICE against her orders." So she doesn't want that to happen. So she held the hearing, and she issued a couple of orders over those hearings. The reporting is Abrego Garcia was in a good mood and good spirits, a light gray flannel shirt and dark slacks. Ernesto Molina faced the brunt of Xinis' criticism, according to Politico. And there were some other people listening in on the phone, he said, but he was left alone to walk the plank. First, she turned to an order that they turned in that said his release was conditional because he was subject to a final order of removal, giving her jurisdiction. They tried to flip the script and argue that the order was not conditional and isn't final, and therefore he should go before an immigration judge to be released on bond. But that's completely different than the several thousand people that Donald Trump has tried to deport and remove. He's argued that none of them are entitled under the Alien Enemies Act or otherwise to a bond hearing in immigration court. But for Abrego Garcia, now they flipped the script and they're trying to argue to Judge Xinis, who's too smart for them, that he's entitled to a bond hearing. She said to Molina, "Look, you elected this form that said it was a conditional release and there has been no final order. I'm taking you at your word, Mr. Molina. I imagine it is possible that order was improvident and could cause the court confusion." That's an understatement. "It may have been done in a manner that was not farsighted," Mr. Molina said. "Did not have the information it needed." See, this is the history of how the Trump administration Department of Justice acts towards federal judges. They purposely send in people who are not prepared, lawyers, witnesses, because judges are supposed to be fact finders. And how are they supposed to find the facts if the people brought before them are purposely kept in the dark and bury their head in the sand? And Judge Xinis and other judges are fed up. Molina said it really should be a bond hearing. She said to him, Judge Xinis said back, "I can't accept these representations. That's a hard pill to swallow. Now you're saying, no, trust us. This order is going to be correct. Why should I give the government the benefit of the doubt in this case?" In other words, the presumption of regularity, which is generally given to the Department of Justice, that its procedures and the implementation of those procedures are regular, is out the window with the Trump administration. You don't get the presumption of regularity. She also was very upset, and it showed up in an order I'm going to read to you that was issued just after it, and gave a very, very harsh lashing against Mr. Molina about a recent court filing. On December 12th, she issued an order barring him from being redetained. He's been out. Abrego Garcia has been out since December the 12th. They listed it in their filings as ex parte. In our world, ex parte means the other side's not present, that only Abrego Garcia's lawyers were there and the judge, and they issued it ex parte. There are circumstances where you are permitted. I've probably done it half 5 times in my life, been able to get an ex parte injunction or restraining order for a very short amount of time. Then the other side is given notice, and then the judge holds a hearing to decide whether to dissolve that restraining order. It's done in circumstances like when you're worried about the asset, the boat, the plane, the money disappearing. You're worried about the person disappearing. You're worried about, things about liberty or just things that'll be very hard to fix if the judge doesn't stop it. Stuttered there for a minute. If the judge doesn't stop it in its tracks, subject to a future hearing to dissolve. But that's not what happened here. It wasn't ex parte here, December 12th order. It was done on notice to the other side, and they litigated against it. So she said to them, everybody signed it, Judge Xinis, and it said, and it's flat wrong. I'm growing beyond impatient with this happening. I want to know who wrote that. And I want to know why all the 4 lawyers who were signatories to that thought it was a good idea. See, when you sign things in federal court, as an officer of the court, you're swearing and attesting that they are true and that you're being honest and truthful to the tribunal. That didn't happen. And look at what cowards they are in the Department of Justice. They send this Molina character in by himself with other people whispering and listening. He said, you had all night to tell me why the petitioner was wrong. This was an emergency of your making. In other words, she said it was an emergency petition, but not an ex parte petition. Do you know the difference? The lawyer conceded that the claim was inaccurate and that he'd comply with the judge's demand for a written explanation of the error. As the hearing concluded, according to reports, the judge gave the government until Friday to submit the precise legal basis if they're going to try to retain him, and she's keeping him out of the holidays. Abrego Garcia, I'm going to show you a clip, emerged from the courthouse to dozens of supporters applauding him and chanting, "Si se puede." Yes, we can. Let's play the clip.
So as of right now, Mr. Abrego Garcia is going to return to his home with his wife and his children and his family members in Maryland. And he will be at home through Christmas and New Year. They can't keep going with this notion that, well, we might do this, we might do this, we might do this, and you should let us do it whatever we want, whenever we want. They have to actually come up with a very specific plan and then justify that plan.
Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popok's new law firm. It's called the Popok Firm. Michael Popok's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas Mighty and legal AFers who are approaching Michael Popok with their cases and saying, can you help us? And at that time, Popok was not able to. So he went out on his own. He started the Popok Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popok's firm is free. Give him a call. See if you have a case. It's thepopokfirm.com, thepopokfirm.com, or you can call 877-POPOK-AF, P-O-P-O-K-A-F. So 1-877-POPOK-AF. Give Michael Popok a call. And I'm really proud of you, Popok. Thanks for all the hard work you're putting in.
And we know from the lawyers, as you heard, the lawyers have a strong position about him. And let's be clear, he'll go to Costa Rica. This fight right now is because the Trump administration wants to punish Abrego Garcia, send him to Liberia, 3,000 miles away from his Latina U.S. wife and children, because he wouldn't plead guilty to a trumped up manufactured a criminal charge in Tennessee that he still stands accused of. And they said, oh, you don't want to plead guilty? Then we're not going to send you to Costa Rica. And they lied to Judge Xinis during the hearing before the December 12th order, in which they said that Costa Rica doesn't want to take him any longer. Costa Rica's security minister came forward and said, we will take him. She doesn't like to be lied to. The order, let me read to you from the actual order. She says that by no later than December 26th, the respondent shall supplement the record. That means the government, with a sworn declaration from a person with knowledge, which they've never done before, who binds the government, which addresses whether they intend to re-detain him, what's the grounds for re-detaining him, and whether he gets a bond hearing or not. Because that was quite remarkable. Now they're claiming he's entitled to a bond hearing when hundreds of other people, they've said out loud, they're not entitled to bond hearings. Then she set up a briefing schedule. She wants a January 14th joint status report. But then here's the shiv. Section, paragraph 4, page 2. The court strikes from respondent's reference to this court's December 12th temporary restraining order, listing it as ex parte. You shall refile a corrected copy of that for replacement. Now, she doesn't actually have in here that she wants a written declaration from somebody about who made that decision to put ex parte in there. But I think that still holds because she made the decision in the courtroom. And then she'll set up further briefing. She wants it clear that her injunction blocking his removal from the United States stands, including the 72-hour countdown and warning, and an order that Mr. Molina send this order to everybody in the Department of Justice that matters and Homeland Security so there's no screw-ups. There's another order that's quite amazing. The judge issued the same day. She thinks she's being recorded in violation of her orders. I mean, recorded. Here's what she wrote. During further proceedings in this matter, no person may possess or transport into the courtroom any electronic device, cellular phone, camera, recording device, smartwatch, smart pen, smart glasses, and or computers and laptops or tablets without the express permission of the presiding judge. It doesn't apply to the Marshal Service, doesn't apply to federal employees. It applies to the Department of Justice. All persons subject to this order are advised not to bring these devices to the courthouse. Something happened in that courtroom. I've been in, as a member of the federal bars around the country, I often, with my federal bar card, am able to bring in electronic devices as long as I keep them on silent and mute, including laptops. However, there are judges that have standing orders against that, and then I got to file a motion to bring in electronic devices. Here's something happened. She's worried about how things are being recorded and if they're being recorded in her courtroom. That's a bad sign for the Department of Justice. Mr. Molina, look around. There's a reason those 4 other colleagues are no longer hanging out in court with you and they're on the phone. You're being asked to do things that are in violation of your rules of professional responsibility, the oath you took to uphold the Constitution and to be an officer of the court. You should rethink your position because this administration is coming to an end, but you don't want your career to. Now, do you? I'm Michael Popok. You're on the MeidasTouch Network. Thank you from the bottom of our heart. Chills down my spine for having crossed the 1 million subscriber milestone on Legal AF, your YouTube, with your help. That's how we grow. That's how we become robust and muscular to fight back against the Trump administration and all those who try to deny you your First Amendment rights, your civil liberties, and more. Help us continue to grow that channel on our way to 2 million. I love saying that. By becoming a free member, there is a link below here. Come over to Legal AF Substack. We're running a sale so you can become a member of Legal AF Substack and support all that we do. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.